Okay, well, I think we can get going here. I welcome everybody to a joint presentation hosted by Howard Employment Law and Ascent Employment Law. My name is David Brown, and I'm one of the co-founders and partners of Ascent Employment Law. I practice exclusively in labor, employment, and human rights related issues. And with me today is Geoff Howard. Geoff, do you want to say hi?
Thanks very much, David. Yes, nice to meet everyone on this webinar. I know a lot of you, I already know because you're clients of ours. So thanks for tuning in. For those of you who are clients of Ascent, lovely to meet you. Very quickly, I am the founder, obviously, of Howard Employment Law, or HEL, as we affectionately refer to it. Our practice is primarily aimed at employers. We focus on all and advise on all aspects and phases of the employment relationship. Often we spend a lot of time, David, perhaps you do too, talking about termination and rights relating to termination of employment. But today we're going to focus on the intake, on the hiring side, and some new legislation. Anyhow, it's a delight to be partnering with our alliance partner, Ascent, in presenting this presentation. And with that, I'm going to turn it back to David.
Great, thank you so much. So yeah, as I was saying in my very introductory remarks, there was a lot of interest in this presentation here today. Usually our in-house webinars, we might get 15, 20, 25 people. Obviously, we're partnering with HEL on this one, so we were anticipating a few more, but we had upwards of 90 registrants for today's presentation. So we're touching on a hot topic that requires discussion. A couple of just quick housekeeping items as we get started. Because we do have high numbers, we're going to be saving questions until the end of today's webinar. That doesn't mean that you need to just sit on your questions throughout. Please use the chat function or the question function that's being provided. But just to kind of make sure that we get through our material and so that we can kind of group or curate some of our questions, we're going to be saving those until the end. Looking at our summary for what we're hoping to go through today, we're going to be talking about what is the Pay Transparency Act and why was it passed. We're also going to be looking at what are the initial rules that we're seeing on hiring and compensation. I'm going to be covering those first two topics. At about the midpoint, we're going to be transferring over to Geoff, who's going to be talking about practical implications for BC employers. And then finally, we're going to be looking at pay transparency, census, and reporting. Now, for most of us, this is going to be a couple of years down the road, but at least it'll give us some initial understanding of what's being expected of us right away. Now, before we jump into that, though, I want to take a stab at, I made a couple of quick polls. This will help us in kind of maybe tailoring or curating our presentation to the audience that we have. And of course, it also makes for some audience engagement. But let's start with, what is our awareness of the Pay Transparency Act? So I've got a couple of options here. What best describes your familiarity with the Act? And some of the options are, I'm aware of my organization's responsibilities, and I'm looking for information on implementation. I have some awareness of my organization's responsibilities, but I'm looking to confirm or clarify what those might be. I'm aware of the PTA was passed into law, but I'm unaware of how it will affect my organization. And then finally, if you're anything like me a couple of months ago, what's the PTA? I saw an email about this presentation and I started to panic. So we'll keep this open for a quick second, give our attendees a chance to respond. Okay, couple of stragglers. 5, 4, 3, 2, 1, and we'll call it there. So, interesting results. Hopefully you're all seeing this. Most people, I'm going to say roughly 80%, are going to fall into our two middle categories, where we have some awareness of the Pay Transparency Act, but we're maybe looking to confirm how it's going to affect our organization, or we're looking just to clarify how it's going to be affecting us. So that clearly isn't a surprise here. And for the 8%, our 3 registrants who said, what's the PTA? You're not alone. I'm sure there's a lot of organizations out there that are asking that same question, and thank you for your honesty. Okay, let's have a look at our next poll here. If I can do this. Clearly, this is not my strong suit. All right, well, we might have to skip polls, unfortunately, because I had another one set up, and it was basically asking, what is the size of your organization? Because as we're going to be seeing over the course of this presentation, it makes a big difference with certain obligations that are going to be imposed on organizations. The first being BC government and major crown corps, and then basically having a timeline that decreases over, or that gets implemented based on the size of the organization itself. But in any event, let's move on. So what is the PTA? Well, this is a piece of very new legislation. It came into law just a couple of months ago in May 2023. And really the intention behind this was to address pay gaps that we know exist between perhaps majority populations and minority populations, or marginalized populations. Of course, the most common one that we see here is the gender pay gaps, but that also is going to be it is also going to be existing across various ethnic communities, or people that don't fit within traditional gender norms, and so forth. So it's going to be applying to BC employers and their agents. And when we talk about agents filling jobs in BC, of course, what we're typically going to be talking about here are recruiters. So this is going to apply to both of them, but it does not apply to jobs that are based outside of British Columbia. So if you're a BC-based employer and you've got staff in Ontario or Alberta, this is not going to affect the advertising requirements for those jobs, or the reporting requirements for those jobs. Now, there's a little bit of ambiguity around jurisdiction here, and I might touch on that a little bit later in this presentation. But just for now, for advertising and reporting requirements, know that it does not apply outside of BC. So this is going to be taking effect in kind of 2 main phases, and then, as we're going to be seeing as well, it's going to be gradually unrolling for reporting obligations over the next couple of years. But basically, there are 3 new rules around hiring and pay that come into force in 2023. First is that there is now a legislated ban on asking candidates about their current or past pay. That came into effect immediately. So basically, in May 2023, from that point forward, it's now against the Pay Transparency Act to ask candidates what were they earning at their past job, where or what their historical pay was. Secondly, there's now a ban on policies restricting pay discussions. That one also comes into effect immediately. And this is quite interesting because obviously, as an employment law lawyer, I put together a lot of contracts for corporations. And of course, in those contracts, there's very, very commonly going to be language on confidentiality, right? And if you look into the language on confidentiality, almost certainly with a lot of these historical contracts, that salaries would have been deemed confidential, and there would have been restrictions in place on discussing salaries with coworkers. And then finally, there's a new rule around job postings. And job postings, whenever you're going to be hiring within British Columbia, they must contain pay ranges. That one's not quite in effect yet. That one's going to be taking effect on November 1st, 2023. But at least for the immediate term, these are the three changes that we're looking at in British Columbia. Now, I mentioned as well that there are going to be some new rules coming down within the next couple of years. So there's going to be obligations on collecting and publishing data on the relative pay of women, including disadvantaged women, for instance, women of color or Indigenous women. And this is going to come into force between 2024 and 2026, depending on the employer's size. So, well, what do I mean by that? Well, to begin with, effective November 1st of this year, the BC government, along with the 6 largest Crown corporations, so we're talking about ICBC, we're talking about WorkSafe BC and the other large Crown corps, effective November 1st, 2023, they are now going to have an obligation to publish that same data, or to report that same data that I just listed there. Now, going forward, private sector employers as well are going to have that same obligation. It's going to start with the largest BC corporations, so basically corporations that have more than 1,000 employees in the province. That's going to take effect on November 1st, 2024. And then kind of our mid-range employers that have 300 employees or more in the province, they're going to have the same reporting obligations on November 1st, 2025. And then finally, we're going to be seeing our smaller employers with 50 or more employees, they're going to be having their reporting obligations on November 1st, 2026. So why was this passed? Like, what's the theory behind this? Well, the basic assumption here is that women and other minorities are paid less, in part because they don't have the information that they need about pay equity. And the theory is that public reporting of pay inequalities or pay inequalities will create pressure on companies to address it. So if we have these historical pay gaps, and we might see them within job classifications or even across job classifications, the theory is that keeping it quiet, keeping it behind the scenes, it's largely going to be disadvantaging our most marginalized groups. While if this information is publicly available, if women and other minority groups know exactly what others within their cohorts are getting paid, that's going to educate them and give them bargaining power when it comes to negotiating their salaries. Also, some of the other restrictions that we saw about not being able to ask employees about their pay history. Well, clearly the intention behind that is you're anchoring expectations to past practice and that you're hoping to carry that forward. That's no longer going to be acceptable practice. So you're going to be looking to negotiate based on the job that's before the individual, and not based on past practice. And also the elimination of restrictions on talking about pay is that this is going to inherently bring a lot more transparency, or at least that's the assumption, that this will create more transparency about pay within pay groups. So if somebody's doing the exact same job and they ask their colleague, hey, I'm just curious, how much are you making? Well, that information is going to give them bargaining leverage. It's going to give them negotiating leverage to seek that pay increase that they're looking for. This is a great quote that I found online. So Success, obviously, it's a very prominent nonprofit organization across the province. They're based in Vancouver, but they're across the province. And they deal with these kind of inequities head on, right? And so their CEO, Queenie Chu, she wrote, BC's new pay transparency legislation is an important first step in reducing the persistent gender pay gap in our society by requiring employers to publicly disclose average pay for male and female employees. The legislation will address systemic discrimination in the workplace that holds women back from achieving their true potential, and will help ensure fairer compensation across our province, so we remain a competitive and attractive place for citizens and newcomers to settle. Obviously, Queenie is focusing on female employees, but I think that there could be a fair comment that these same benefits are envisioned for other minority groups as well. We don't necessarily have all those details yet of how they're going to be in place, but that's what I understand the vision to be, is that we're looking to basically eliminate the information barriers that might exist to allow for fairer compensation within our workplaces. So on hiring and compensation rules, well, employers, as I've talked about, they're not going to be able to ask applicants about their current or past pay. I'm going to go through this pretty quick because I think I've already touched on it. But here the intention is to stop employers from underpaying women and minorities because their current pay or their expectations are low. And then in addition, ban on policies or practices of restricting or sanctioning employees and applicants from discussing pay. And this will allow applicants and employees to gather the information on which to base their pay expectations. And as I mentioned, it will allow for greater negotiating power when discussing pages and wage increases with their employers. Okay. Finally, as of November 1st, all job postings must include a pay range. The intention here, of course, is to ensure applicants know the full range so they can ask and they can use that for bargaining purposes. This does not apply to non-public job posting. That's a very important point to stress here. So if there are internal postings, or if you're an organization that's looking to hire without a full job advertising, so maybe you're sending out emails, or maybe you're kind of approaching candidates and asking them to meet you for coffee so that you can have conversations with them, or perhaps you're looking at a headhunting firm that's going to be basically doing like kind of a narrow search to identify and recruit potential candidates. Well, in those kind of instances, the pay publication is not going to be necessary. Rather, what we're going to be seeing in those instances is that it'd be far more discreet. When we're talking about these job postings, we're really talking about the jobs that are going on to Indeed or onto LinkedIn or the other kind of online job forums. From that point forward, the expectation is that they will be published. Also, just want to clarify that this does not mean that all jobs need to have a pay range, or that the employer must provide like a formal pay grid for all jobs. This only applies to posted positions. And as well, if your pay range is a fixed number, if you pay $25 for this job and you don't pay more than that, then obviously you don't need to have like a range of salary that the person can be expected receiving through there. It's just a single post.
David, it's Jeff. I have a quick question for you.
Thanks, Jeff. Yeah.
Do you consider that if an employer posts a job only on their own website, do you consider that the PTA will apply?
Yeah, good question. My expectation in that kind of a scenario is that it will. If it's going to be a public-facing job posting, and that it's going to contain all of like the typical requirements that you would see in a job, like requirements of the position and so forth, my expectation is that that will have to contain the pay range. Now, this is all new territory, right? We haven't seen this before. Do you have, and I would invite other interpretations. Did you have thoughts on that yourself, Jeff?
No, I agree with you. I think that's absolutely within the meaning of published, but some people may see a distinction between publishing it on a more a common platform like Indeed versus just on your own website.
Yeah. We're chugging right along here. So I think, if it's okay with you, Jeff, we've got a couple of questions, and before we transition into the second half of the presentation, maybe let's have a quick look at these questions, and before we wrap up the kind of the first portion here. So one question that we got is that this act applies to all BC employers. Does this include employers whose head office is elsewhere in Canada but operate in BC, or are they going to be excluded? So with respect to this question, my understanding is that if you are advertising for positions in BC, regardless of where your head office is located, you are going to have to be respecting the Pay Transparency Act. So give a simple scenario. Let's say you've got a company that's based in Toronto. Their main office is in Toronto. Maybe they've got 300 employees out in Toronto, but they've got a small group or a regional office with 30 employees here in BC. If you are looking to fill positions within that BC office, I think you're going to have to be following the pay range rates for that office. Next question. How do these obligations apply to franchisors or their franchisees? That's a fantastic question.
Can I jump in there? Can I jump in there,
Please
David?
take that one. Yeah.
Yeah, I think the classic franchise structure that we see would be often a national franchising organization. And keep in mind, some of those, and I have a couple of these clients, they will have what we call corporate locations or corporate stores where they actually are the employer. So you got to be careful if you're a franchisor, if you're actually operating with enough employees in BC, whether it be head office, your regional manager, or some corporate stores that you hit, for instance, the 50 employee threshold in BC, then the pay transparency reporting will kick in, and certainly all of your practices in hiring, say, a regional manager for BC, you'll have to comply with the other rules that David has just gone over that apply starting this year. On the other hand, there's nothing in the act that aggregates together a true, independent franchisee with the franchisor or for that matter, aggregates the number of employees at all different independent franchisees and says you have to report. So I don't see any basis for taking that position in the legislation, which is very short. But it's a good reminder. One of the things I happen to know that my franchisor clients do is they help what are often very small business operators with compliance with new legislation. So I would encourage it, if there is someone on this call as a franchisor, maybe make sure you get a note out to your franchisees. They may not ever have to report on wage gender equity, but they will have to follow the rules that David's just been over, and we're going to talk about some more in a minute on hiring if their franchise locations are in BC.
Yeah, I think that's a great answer. And if I can just piggyback on that, I think you need to kind of look at the franchise or franchisees from the perspective of the corporate entities. So if they're separate corporate entities, like for example, I've purchased the rights to franchise a location, then you're looking at within the scope of that business, not including like the broader franchise. Like somebody who owns a Tim Hortons is going to fall under different rules because they might have a staff of 20 people than Tim Hortons, the corporate entity, right? Okay, another quick question here. Angela asks, does the pay range on postings come into effect on November 1st? And does this apply to all companies regardless of size? My understanding is the answer is yes. The distinction that I made earlier on some of the anniversary dates going forward, that's going to be with respect to the reporting requirements that Jeff is going to talk about in the second half of this presentation. Another one here. Maybe Jeff, you want to take a stab at this one? Leah asks, for organizations that currently have verbiage in their contracts about confidentiality around salary, do those letters now need to be written, amended, and if so, do they need to provide consideration?
Well, first of all, thank you, Leah, who I know well, who's a leading HR consultant and often is doing recruiting. I would say this: yes, going forward, you should not be asking employees working in British Columbia to be signing clauses or receive policies that say they cannot discuss their salary or their bonuses, et cetera, with other employees or indeed with outside job applicants. Sometimes you get those conversations. You should get rid of them. Certainly, you shouldn't be doing anything going forward like that. And then, I would say, by virtue of this law, the existing language and clauses and policies are rendered invalid. So you're not allowed, of course, to take any steps to try and enforce them now with this new rule in effect. I don't think you necessarily have to go back and get everyone to sign a new agreement, nor do you need to give them something to sign it. But you just need to be aware that those clauses are no longer enforceable.
Yeah. Okay. Well, with that, I see there's still a couple of extra questions here. We will circle back and cover these as the presentation goes on, and especially near the end. But let's turn it over to Jeff to talk about some of the practical implications of this legislation.
Thanks. And, I want to thank people who are asking the questions because it makes a lot more interesting both for the presenters and I think for the attendees. And we will stay on if need be extra time to get to all the questions. So, what are some of the practical implications of these new rules? And some of them, David's talked about what the government thought it was trying to achieve by bringing these in, but there will be, some perhaps unintended secondary consequences. I know one challenge that some of you who either, work for and do hiring for a smaller business, and some of the recruiters that I know are on today will struggle with is it was relatively common for small, even medium-sized businesses to sometimes just post a job saying, something like pay commensurate with qualifications. And one of the reasons was there was sometimes a concern that look, if we may not be paying at the top of the scale, but we'd like to get good candidates applying, and then we'll try to convince them that there may be offsetting benefits of working for us. Maybe it's flexibility, it's location in a particular community, maybe it's in bonuses that we pay, that sort of thing. And so unfortunately, the act is going to shut the door on that kind of a posting. And you're going to have to put something down that is, realistic about the range of pay that you are offering. And, that may turn some people off. Obviously, many job searchers, candidates have lots of options, and they may basically look at your ad and go, well, that range doesn't do it for me. And they never get that opportunity to meet you and hear the pitch for why this would be a great place to work. Again, I think a lot of the unintended consequences are for small and medium-sized employers that may not even have an internal HR function. I think some of them are going to struggle with what pay range they should be advertising for. A common one that I see is, an organization grows to a certain size, maybe 30, 40 employees, and they say, boy, we need to get an in-house HR person, but they've never hired anyone in HR. They may have expertise in whatever their industry is, and they really don't know, what should we be offering to attract at least good applicants. So that, just a little more homework will need to be done. That's probably something they need to do anyways. Obviously, one place they can get that kind of information is from recruiters. Another point, we may see, there are certain businesses, particularly, in the private sector, where there can be real sensitivity about pay and where there's quite a bit of mobility of employees and perhaps a shortage overall of qualified employees for the industry. And so there can be a lot of sensitivity about disclosing your pay. And of course, when you post a job, you're going to have to make some disclosure of your pay. And some people who are very concerned about not giving away too much information to their competitors who may be looking at those job postings may decide to post very wide pay ranges, which may render them maybe not that really meaningful for the people reading them. But so I do expect we'll see some of that. David, if you could flip us to the next slide. So what are some practical implications? Obviously, I just touched in answering Leah's question on, it is a good time to check for any policies you may have or terms in your standard form of employment agreement that would prevent discussion of pay. I know certain industries, finance industry, where a lot of big bonuses are paid and where employees are often earning, as much as 50 or 80% of their pay in the form of bonuses. There can be a culture and rules around, you can't talk to anyone else about this. You're going to have to drop that culture and you need to delete those clauses and policies. Take a look. Another place you may not be thinking of immediately is most well-drafted employment agreements have a confidentiality clause, and often buried in the list of things that are deemed to be confidential information is words like information about pay or compensation to other employees. So you need to get into those clauses as well and strike out that particular wording. All right, so what are some other action item here, practical implications? I think there's quite a few application forms out there, whether they're online or paper, that do ask applicants for their current pay or past pay. Usually it's their current pay. So, it's a good reminder. You need to take a look. You may have an online template that people fill in as a first step in applying for a job on your website. Take a look, make sure you're not asking for that information. avoid avoid asking. You now have to stop asking applicants about their current and past pay. This, may be a little more difficult than we realize. It's, the average man, most hiring involves perhaps an HR person or a recruiter who's a specialist and may know about the Pay Transparency Act, and then typically a manager, one or more managers who don't know anything about this, unlike the people who are attending this webinar. So one of your missions, those of you who are attending on behalf of your organization, is making sure everyone out there in management knows, hey, you can't ask. Sometimes probably towards the end of a first, or more likely a second interview, the topic can come up, and sometimes one of your managers is going to say, well, what are you earning now? What will it take to bring you over here? And that whole conversation, you have to train your managers to stop and not ask it anymore. There is an interesting issue. Well, what if an applicant, a candidate, volunteers information about their current pay? Will that violate the act? I think it's going to depend on the context. If the candidate in the interview says, look, I'm interested in this job, but based on the posted range, you're going to have to pay me at the top, because otherwise, I'm earning that much already at my current job. I don't think there's anything wrong with that. Obviously, that's been volunteered by the applicant. But of course, if the employer tries to sort of wheedle it out of the candidate, that would be a breach. You're sort of asking a leading question. Well, we could only pay in this range if you were to show that you're already earning it. That might be viewed as an indirect way of violating this legislation. Next slide. Thanks, David. What are some other practical implications here? Small and most larger employers already have information about pay rates. Sometimes their internal, external consultants are researching going rates, or their industry may provide them with data about going pay rates. But this obviously means that small, medium enterprises are going to have to do more homework on what the going rate is for a job, particularly a new category of job that they're creating. Employers facing skill shortages of workers and who are worried about their employees being poached based on posted pay ranges, may need to up their pay, but they have to remember that posting could be seen by incumbent employees. So there are going to be, I think, situations where you may have a range of pay for people doing essentially the same job, and it may be that you've had to up your pay in recent years to fill vacancies, and you've been able to sort of get by, and the incumbents who are being paid less don't know this now, and then part of your strategy may have been when you posted jobs you didn't put the exact pay range. Well, now you're going to have to come clean, and so that may give rise to some interesting discussions between employees and their managers, saying, hey, you just posted this job and you hired Helen, and I'm pretty sure she's getting near the top of this range, and I'm still only earning this, even though I've been with the company for 5 years. So brace yourself. The more transparency is going to mean more demands and requests for increases to match new hires where they will have that information. So next slide. David's alluded to this. I don't want to rehash it too much, but the second big initiative inside this legislation, the pay transparency reporting, does come into effect for employers on a phased basis. And as David mentioned, a few very big Crown Corps and the BC government itself, they're going to do the first round of reporting this November. So it's not very far away. And then you'll see for private sector, most of you are, employed in or work as recruiters in the private sector. You can see the private sector really only starts to be affected starting next year. It starts at the 1,000 employee level. There's not that many 1,000 employee plus employers in BC. So that's a small group of relatively sophisticated groups with large numbers of employees. But you can see that the idea is this is going to drill all the way down until 2026, that employers with only 50 employees in BC will have to report. It's an interesting approach. I mean, if we go back to the premise of the legislation that David explained, the idea is that by publishing this data, you're going to show up inequities and put pressure on companies to correct those inequities. But we know as a basic matter of statistics is the smaller an organization, The less representative, perhaps the sample of, of wages and sex data, or sorry, gender data, is going to be, and that, that it may be that anomalies can be explained by unique circumstances in businesses that are as small as 50 employees. And by the way, this is going to be an ongoing obligation for everyone who has 50 or more employees. It's not a one and done sort of reporting. It'll be something you'll have to do. I believe it's going to be annually. So obviously, for those of you who are HR consultants on this call, good news, probably some of your clients, particularly in the sort of 50 to 1,000 range, are going to be calling you and asking for your help in complying. So next slide, please.
Yeah, Jeff, before we move on, but can you quickly just touch on if there's any known obligations for reporting for employers with less than 50 employees? That was one question that was asked to us.
Yes, good point. Yeah, no, at least the legislation currently doesn't contain anything that suggests that employers with under 50 employees in BC will ever have to report. That could change, of course, over time, both ways, and the government could amend the regulations and change that threshold. But so far, that looks like you're safe. All right. So, how is this going to work? We're learning along with you, but obviously the first step before you can report anything is you're going to have to collect gender information from employees. And there's a government standard that you can go and click on now, and you'll see it's important to understand there's a distinction between sex and gender. And there's obviously, in today's world, we know there's more than just sort of, male, female. In the gender world, there are several different, other self-identifications, and this is very much going to be, based on the model. Gender should be reported based on self-reporting by the employees. So then, once you've done the census, you will of course have to gather and match, people's gender identification with their pay, and what I've just learned recently is apparently you're going to have to break it out between sort of base pay or hourly pay, that presumably would also include salary for people who are salaried. Overtime, you're going to have to look at information and report separately on overtime earnings and bonuses. And I certainly think that's a good approach, because there's a good chunk of industries where above a entry-level position, a large portion of what people earn are going to be bonuses or commissions. It'll probably incorporate commissions. And so, it wouldn't be a complete disclosure if we didn't break it out between these. So you are going to have to break out your data. And the other thing that I've just learned from something the government's put out is you won't actually be reporting exact numbers or ranges of pay. What you'll be doing is providing a gender-based breakdown by quartiles of pay within your organization. So you'll be having to, for instance, report that, with respect to base pay, the top quartile, so the top 25% highest paid employees are, 60%, identifying gender as, as cisgendered males, for example. So that's the kind of reporting that's going to be done. So it won't involve actually publishing absolute dollar numbers, but it will involve providing information about the quartiles ranking by gender.
Yeah. Do you mind if I just add a few words on the gender and sex data standard?
Absolutely.
So I had the opportunity, the immense pleasure of reading this document. And it's important to recognize that for right now, this is really a government document that's designed to be used by the government. So I fully anticipate that it's going to be evolving as this program unrolls. But basically, some of the methodology that they place in there, as Jeff alluded to, it puts a lot of focus on distinguishing between sex and gender. So somebody may be biologically male, but may identify as a woman or in a non-binary capacity. But beyond that, they also give some recommendations on data collection, which is quite interesting. And it seems like the preferred method of this kind of gender and sex data collection is by using some form of electronic or online form, because confidentiality is more likely to be produced. You're not having people like manually complete hand forms, which contains obviously very sensitive information, which can get lost, or now you're responsible for storage of this, and so on. So that was one of the main takeaways that I had, is that I expect there's going to be some kind of online or e-census that they're going to be encouraging employers to use to gather this information from their employee groups. Okay,
Thanks, David. If you could take us to the next slide.
you bet.
You probably will have questions as you get into this process, if you are an employer or a consultant to an employer that's going to have to comply with this part of the legislation. One question, who's going to decide, what gender, an employee claims. It appears pretty clear that the standard is going to be self-identification, and that will include the right of employees to decline to identify their gender. So who knows what we're going to see there. It may depend on where you work in your workforce, but that's obviously, potentially going to complicate matters. The second point, I think I've just covered how will employers have to report. It looks like it's going to be looking more globally at the BC workforce and looking at quartiles, but it may be quartiles on base pay, quartiles on overtime, and quartiles on bonus or incentive type pay. Obviously the fact this is being made public means a lot of employers are going to be concerned about what their data looks like. And, it is obviously the smaller your organization and perhaps what industry it's in, you may be concerned about, well, what kind of picture is this painting of our organization? We think we're giving women and Aboriginal women and women of color good opportunities, and yet, the way our numbers are coming out don't reflect that, and may be embarrassing for us. That risk, I think, is definitely going to be there. What I don't see in the legislation so far is any prohibition on an employer, for example, offering some explanation. Like, for example, in a number of our highest paid categories, we've only had women join the organization over the past 5 years, and most of our long-serving employees are male, and that is why pay has skewed, showing higher pay for males. So length of service, other explanatory factors. So I as far as I know, it looks like it'll be open for you to have some explanatory text in your reporting. Nonetheless, the data will be out there and may start some conversations. I'm now going to switch gears very quickly to talk about something that's happening in Ontario. We've only added it here because it relates to recruiting. It's quite different, but it does relate to recruitment and temp agencies in Ontario. And I know not everyone in this webinar, cares or is doing anything in Ontario, but I thought I would just mention there's a whole new regime of registration required for both, classic recruiter or headhunter agencies, as well as temporary agencies that are operating in Ontario. And unfortunately, there is no threshold. I know some of you on this call may be recruiters. You may have a client, perhaps they're based in BC, but they say, hey, we need you to find a sales manager for our Toronto office. Well, that should trigger your awareness that you need, according to this new Ontario legislation, you need to be registered in Ontario as a recruitment agency. So similarly, even if the head office making this decision, and perhaps your relationship, if you're the recruiter, is all outside Ontario, if the job that you're recruiting for is located in Ontario, you're going to have to comply with this. And then on top of that, to make this even more challenging, there's a rule essentially saying that as of January 1st, 2024, so that's not too many months away, Ontario employers are only allowed to use recruiters who've got themselves registered and therefore appear on a list of registered recruitment and temp agencies. So there'll be sanctions for employers who are using non-listed agencies. Now, in BC, there's already a requirement. I hope anyone in here who's doing recruiting knows this, to be registered, but it's not an expensive one. It's a very modest fee, and there's not a lot of hoops that have to be got over. Unfortunately, this new regime in Ontario requires any agency conducting either recruitment or temporary, temp employee agency services to post with the Ontario government a $25,000 letter of credit as a condition of getting your licensing. So all I can say is that's a lot. If you are occasionally filling an Ontario position for one of your BC or Alberta-based clients, That's a big requirement that you're probably not going to want to satisfy. So there may be workarounds, partnering with a local recruiter that has the letter of credit, but you should be aware of this new regime. So I'll leave it at that, because I know most of you this may not be of interest. But so let's go to the last slide, David. Our conclusions. We're repeating ourselves a bit here, but coming out of this webinar, it's great, a time to go back to the office and look at all your online or paper application forms. If you have standard interview questions, or perhaps questions that you ask using AI, or some kind of standard set of initial questions that you ask people to fill out online, make sure you're not asking anything that violates the act about past pay. You'll need to set up some training on these rules. They're simple, but they're new for your HR team and hiring managers, which is probably most of your managers. If you are an employer here and you're using Recruiter, just touch base with your recruiter. Make sure your recruiter is aware of the new rules around hiring and pay. And as we've mentioned already, go through your contracts or your policies, anything that's touching on that says you can't talk about or disclose your pay or talk about someone else's pay. You need to delete that policy. So David, maybe throw it back to you to get through the remaining questions.
We have plenty of questions here, so we're going to take a chance going through these. I want to actually start by talking briefly about something that wasn't in the presentation here today, and that's a quick word on enforcement. So what happens if we are non-compliant, and what implications does this have for us as an organization? And well, the short answer of that is right now, I don't see any enforcement or compliance measures. I don't suspect this is going to be a toothless tiger for long. I expect that what the government is doing right now is that, as they often do with unrolling these kinds of programs, is they're going to be heavily focused on education and on bringing employers online. They're going to be really testing the waters with their own crown corporations. And I fully anticipate that in the coming years, we are going to be seeing amendments to the current legislation that will include some kind of oversight or enforcement mechanisms. So first question that I'm going to give to you here, Jeff. We've had a number of people that asked, what is a pay? What is a pay range, and what goes into that? I think you touched on it briefly in your talk, but do you want to expand on that in what should we consider pay for advertising and range purposes?
Yeah, I think that's great. I mean, there's going to be, there's probably, I can't think of all the scenarios, but obviously, as you point out, sometimes it's very clear. We pay $25 an hour, period, and we don't vary it. And of course, that is satisfactory. If that's the pay range is one specific number, that's all you have to publish. Dealing with perhaps a more middle to upper level job, it's pretty common now to have base pay, salary typically, and then some kind of variable, usually some kind of bonus. And I think it's going to be acceptable to publish two separate ranges. I don't think, or if you decide that you wish to only publish a total compensation range, I think you can do that too. At least I haven't seen anything yet that would say you can't. So that'll be your option, and it'll be up to the employer to decide how to do that. As far as I can see.
I'm looking at the legislation right now, and it's quite clear. It says salary, wage, or commissions. I guess there's no controversy there. Money that is paid or payable as an incentive in relation to hours of work, production, or efficiency. So this, to me, kind of speaks to the formula-based bonus that would be included. And then, in addition, money that is paid or payable at the discretion of the employer. So that would be the discretionary bonus. So if there's some kind of discretionary bonus that we should anticipate, it would be listed in there as well. Now, how to quantify that at the start of an employment relationship, that might be tough, but that's typically what goes into creating the pay range. Okay, next question. Should we anticipate that there will be guidelines on what a salary or pay range should look like. My expectation here is that there won't be any kind of published guidelines on pay ranges. What I would expect on this is that you're going to be looking at industry standards in your community, in your market, and that any range that you're going to be created is going to be kind of keeping yourself competitive with other employers in your market space, both for that industry and for that type of person that you're hiring for. What do you think, Jeff? Anything to expand on that? Like, should we anticipate that there will be salary guidelines provided for employers?
I don't think so, at least not initially, unless they run into trouble. I agree with you.
Okay. Next question. This is a good one. Do the new rules on pay and hiring apply to contractors? What do you think, Jeff?
I think no. I mean, the terms that are used in the Act all refer to employment. That being said, we've certainly seen in other contexts, Employment Standards Act, where individuals have set up relationships in writing and acted as if the service provider was a contractor being reassessed retroactively as one of employment. So I think some of that same case law, probably primarily from the Employment Standards Act, is going to flow over to this, so that there could be people who are being paid as contractors who could be held to be employees. Therefore, any position being posted should have a pay range, etc., and the other rules would apply.
I think that's a good answer, and I think that as we kind of move through and continue to kind of explore this, this gig economy and a lot more contractual work being done in the economy, I anticipate that in the coming years that there's going to be a certain tightening of screws on contractor relationships. And while I don't know how it's going to show up, like in the Pay Transparency Act, I think there's globally going to be more oversight over some of these contractor relationships in the future through changes to our legislation. Interesting question here. Salary expectation. Is it okay to ask about salary expectations? I think the answer is yes. I don't see there being any concern about that. I think that forms part of any normal, healthy conversation when hiring and onboarding somebody. And in fact, I think a lot of these changes are to encourage that conversation about salary expectations and to equip the employee with more transparent information so they are better positioned to answer, to have that conversation.
I agree, David. I think that's exactly right. Obviously, if someone says, I want this, you can't then go, well, you can't be getting that where you are now, or something like that. There's going to be curbs on that kind of a follow-up.
Yeah. And a similar question, are we able to ask about their compensation expectations within a range? I think there's no issue to do with that. That really does come down to, market economics and negotiating the price of a contract, which effectively is what a salary is, right? You're negotiating the price of the employment agreement. Okay. This is a good one. Diane Green asks, for the reporting piece, if your organization is 2,000 people, but you only have 150 in BC, are we required to file a report in 2024 or in 2026? And I was actually thinking about this prior to this presentation, because what happens if you're a national corporation, but your local employee body is a much smaller group? What threshold are you following into? I haven't seen this specifically addressed in anything that I've read, but my inclination is to say that you are going to be in the smaller reporting group. What do you think, Jeff?
No, I agree. I think there's a general rule of interpretation of statutes. The BC government only has the power to regulate things, including employment practices that are happening in BC. And so it's implicit that when you talk about these thresholds, unless expressly drafted to the contrary, generally it's always been taken to be understood that speaks to the threshold level of employees inside of British Columbia. So, I would give the same answer as David. That being said, I just happen to know in Ontario that had traditionally been the case for some of the threshold requirements in the Employment Standards Act there. And then the divisional court out of the blue in Ontario said, nope, we're going to go based on global headcounts. And, employers are still reeling from that one. So I don't anticipate that happening, and it hasn't happened yet in BC, but just to say that things can change.
Yeah, I could certainly see that changing too. Okay, let me put this one to you, Jeff. So in HR circles for a long time, rightfully or wrongly, it was like totally taboo to ask about human rights characteristics in a job interview. You wouldn't ask somebody about their religion. You wouldn't ask about if somebody has a disability. You wouldn't ask about somebody's marital status. Like these are no-go zones. How do we fit that within these new disclosure obligations about gender
Well, that's
and presumably gender and presumably other minority characteristics?
yes, because we've alluded to as we understand, there's possibility that reporting is going to have to be further fine-tuned from gender identifying, female to also female Aboriginal or female visible minorities. So, it's a great question. Personally, I don't think you should change your practice about not asking about these things in hiring. I mean, I think the Human Rights Code still requires you to hire on merit and not. And if you ask for these characteristics, you of course are opening yourself up to someone saying, well, when I told you that I had this disability, suddenly I didn't make the short list. Interestingly, Ontario's Human Rights Code actually has a specific provision saying you can't ask about these things unless you can show that it's a special case where you're going to be an attendant in an all-female facility or something. So I would stick with that. But obviously, in this new era, once people become employees, then you will have to, if you're part of the employer group that's 50 or above, you will have to be asking them what gender are you, and then you'll be aggregating that data and using it to make these public reports. So it's kind of ironic. It is sort of a change in philosophy, but I wouldn't change your hiring practices at this time.
Just to kind of piggyback on that, one thing that I was reflecting on is that there's nothing that says that when we're talking about the census and the surveying of staff, that says that the survey can't be anonymous, right? And so perhaps what we could look to do, especially if we're using one of these like online survey tools, perhaps what we could do is we could break it down into the various cohorts.
David, I'm just going
right?
to drop the thing. I think it's going to be difficult to correlate pay because you're going to have to look at the actual individual's pay as the second part. So I think it won't be possible to do everything in complete anonymity.
Well, only if you were to basically like break down pay into the quarters and then survey based on that. But in any event, there might be some solutions here to that. As a follow-up question, Lisa Fletcher asked, what happens if they don't want to disclose? And I can probably speak to this because in the gender and sex data standard that I was reading, you should be providing an option of do not wish to disclose, and that's perfectly valid. So that would just be like another reporting criteria, is that X percentage of people chose not to or did not disclose.
David, can I jump in and grab a couple of questions that are related here? A couple of people are asking,
Please.
what about, I post a range as I'm now required to do, but then my client realizes, oh, the person I really want or the realistic going wage for this job is higher. And I don't think there's nothing in the act that says you can't do that. It's, I guess, still going to be the case that it happens, from time to time. And nor do you have to go back and correct your posting. You just, I think, have to post in good faith what you believe the range is that you're prepared to offer at the time you post the job. There's no follow-up requirement as to what you actually paid for the candidate you hired. Another kind of related question, from another person is, well, what if I want to do a spot bonus to someone, a one-off because they did a great job, perhaps completing an office move for us. I think so far we don't have a lot of detail about what you need to count towards pay, but I think you would have a reasonable basis for saying, well, I'm not going to count that in the pay and where I put, this person in the quartiles, etc., because it's a one of a kind. But on the other hand, as David's pointed out, saying you have discretionary bonuses doesn't mean that isn't pay that isn't going to have to be counted, and form part of the data that goes into your reporting.
Yeah. Okay. Another question we had here was, do we have any sense as to whether similar legislation will be passed in other provinces? I'll take a first stab at this. I haven't seen or heard about other provinces doing something similar, but I can comment that what we typically see in Canada, if something is viewed as a good idea in one province, it's often taken up in other provinces fairly quickly. How about you, Jeff? You have a more national-based practice than I. Are you seeing similar legislation in other jurisdictions?
Yes, we are seeing some of this coming across Canada. I happened to be attending a conference where they mentioned that I think it was Newfoundland, they're going to apply some of these similar rules and the reporting initially just to the public sector, and I expect we will see it in other provinces. I don't have them at the tip of my tongue right now, but there are a couple of the provinces that brought in some of the initial rules we talked about asking about pay and past pay and pay ranges. So it's not, this is a movement. It actually, some US jurisdictions have introduced it as well. So it is a bit of an international movement.
Yeah. Okay, well, I think that's going to be bringing us to the end of our presentation here today. We did our best to kind of go through most of the questions. If you have a specific question that did not get answered, Jeff and my contact information is on the screen. Please don't hesitate to reach out and have a conversation with us about that. I mean, we're all, that's the whole point of this here, is to disseminate this information and to make sure that you're getting answers to your questions. I got to say, this was a fantastic presentation. It was short and sweet. It was a pleasure to present with you, Jeff. It was well attended with a very engaging audience. 5 stars.
The pleasure was mutual, and thank you, all of you who took the time out of your busy day to tune into this.
Yeah. Now, just one final point. We are recording this presentation, and we will be publishing it to the Ascent Employment Law's YouTube channel. We're happy to send out a link to our attendees here today with the link to that once it's ready to go. So thank you all. Have a good rest of your afternoon, and we'll talk to you next time.